I want this all sessions to be available to you uh, as and when you want to watch in the future. All right, here we are once again in the beautiful evening. The sky is beautiful here again in Pune, quite crimson and mixed with the gray color. And with this, I would like to start with what we have started yesterday and the day before. That is the topic of terrorism. You have entire separate unit of the international terrorism, and all this could come in your examination. And as the examination, final examinations are supposed to be conducted in mostly, hopefully, in objective way. If I'm not wrong, I stand to be corrected. Then these slides, these presentations will be very much helpful to you whenever you will prepare for the final exam, because much could be asked from these units that I'm dealing with. So, keeping it forward from where we have left yesterday, we have seen and we have discussed the situations that are going on in between Israel and Palestine. There is, I think, the day before yesterday, and the situation is getting worse and worse. The U.S. president, the United States in the Security Council has blocked the Security Council to issue any press statement because the US president is very much fearful of his own lobby that is there in the United States and Washington DC, because he don't want to lose the support of Israel, and as a result, the US is very skeptical when it comes to the coming to the support. And however, they have issued a ceasefire press conference statement just today, and wherein he has called for ceasefire of you see the situation between Palestine and Israel. However, Israel is very much firm, and they are issuing warning again and again to the Palestinian militants to come and surrender. And they're saying that they are not going to stop until every one of them surrenders unconditionally to the Israeli forces. So the situation is really interesting. We'll get to see what happens in next 2 3 days, and still there are so many scary videos and so many scary images that are being coming up, and the situation is horrible. We'll discuss this maybe some other time. Coming back to our topic, I have just given you an idea in my some of the previous lectures as to what international law provides for the regime of international law when it comes to fighting the terrorism. And we have seen that there are as many as 19 international conventions, and also there are certain resolutions which have been passed by the General Assembly as well as the Security Council. And then we have moved towards the law or the combat exactly, um, or the way the United States has you see combated the menace of terrorism in their country when it happened. And mostly, if you can see, the laws that are there in the US, they have enacted post 9 and 11 attack only. So these were the 6 to 7 legislations that the US has come up in response to its 9 and 11 acts of terrorists. And then to begin with, we have briefly seen yesterday the Anti-Terrorism and Effective Death Penalty Act of 1996, then executive order which talked about the freezing of assets, or you see the stopping of the financing that comes to, or that comes and goes to the terrorist causes. Then very importantly, there exists a USA Patriot Act, which was amended recently in the year 2006, which became the focal point of of all dealing with the terrorism there in the US, and it provided so many relaxation to the executive so that the executive can take action against those who are even suspected of carrying any terrorist activities. Then we have also seen some of the Homeland Security Act provisions 2002, which has created mainly the Homeland Security Department in the US, and it became the focal point of handling the intelligence sharing stuff in the US since then. Then they have also come up with the Safety Act, that is support anti-terrorism by fostering effective technology act, because modern practices, they have proved time and again that how much crucial a technology could be when it comes to the terrorism. So right way back in 2002, they have come up with the Safety Act. Then another important act, they came up with the Border Protection, Anti-Terrorism, and Illegal Immigration Control Act of 2005. Then they also had the Real ID Act. Most importantly, and the most controversial legislation that the US has legislated after the USA Patriot Act was the United States Military Commissions Act of 2006. This became the bone of contention and a matter of litigation in many of the federal courts in the US. And time and again, the court had declared this military commission's proceedings as unconstitutional from time to time. So this was all about the Anti-Terrorism Manufacturing Security Act. This act had came up before in the background of or in the backdrop of Oklahoma City bombings, and it worked totally upon the habeas corpus. It presented several definitions. Then we have also seen about the Executive Order 13224. This mainly focused on the foreign assets control and freezing of the assets that goes to the terrorist people or the organization so far. Then, apart from this, we have also seen some of the provisions of the USA Patriot Act, which made the changes in the FISA and the ECPA and the MLCA and the BSA Act and the Immigration and the Nationality Act, so far and so forth. Then we have also seen how USA Patriot Act has enhanced domestic security against terrorism, how FBI's technical support center was being more authorized, and the executive were given more and more power. There were also enhanced surveillance procedure. Amendments were made in the FISA and ACPA, and this is how foreign intelligence could be gathered most easily by the US authorities. Then we have also seen some provisions about the anti-laundering to prevent international terrorism. The Money Laundering Control Act and the Bank Secrecy Act was also been, amended in order to bring more and more transparency into the functioning of the financial system of the United States. Then border security have also been strengthened by way of making amendments in the Immigration and the National Act of the 1952 and to give more law enforcement and investigative power to the US General Attorney. Then we have also had a look at how the Patriot Act cares for the victims and the families of the victims. They have made amendments once again to the VOCA Act of 1894 and provided for speedy compensation to the aid to the families of public safety officers and so on and so forth. Also, we have seen how the amendments were made in the terrorism of criminal law in the domestic law setup and how different definitions have been changed from time to time. Then we have seen Homeland Security Act 2002, which established the Homeland Security Department, which became the focal point of gathering the information. Then these are the Safety Act changes or amendments which have been made previously. And this became, in fact, a groundbreaking change that provided broad thought reform to encourage development of safe and effective anti-terrorism products and services which are critical to national security. We have then also seen how Border Protection, Anti-Terrorism, and Illegal Immigration Control Act of 2005 came up, and it actually worked on reality on the ground, and it prevented illegal immigration of any kind. Then Real ID Act, just to make sure that the people are the genuine people, the Real ID Act came and it modified several US federal laws as well, which pertain to security, authentication, and issuance, which was provided only to the citizens and the nationals of the US. Then came the most controversial, as I said, the United States Military Commission Act of 2006, and which is also known as HR 6166, which was drafted in the wake of Supreme Court's decision in Hamdan versus Rumsfeld. We will shortly see what these decisions were. And this act was to authorize the trial by military commission for violations of the law of war or for any other purpose. And it authorized the president as the supreme commander of the military and and entrusted with the power to make established military commission to try the offenders of the war crime or the suspects of terrorists. Then these were the main provisions or applicable provisions of the Military Commission Act of 2006. Section 810 deals with the Uniform Code of Military Justice relating to the speedy trial. Then Section 831 deals with the compulsory self-incrimination. Then generally we have the rule against self-incrimination, but here in this act they had made it compulsory self-incrimination. That means it gives full power to the investigative agencies to extract the information from the suspected people. In Section 832 relates to the pre-trial investigation, and it also clarified further that no alien unlawful enemy combatant subject to trial by military commissions under this chapter may invoke the protection of the conventions. This was something very much again, ironic, which has been provided, because if you are an enemy combatant of the Military Commission Act 2006, then you cannot say that you are protected by any of the conventions to which United States has a party or is the party. Then this is how they have defined the enemy, lawful and unlawful enemy combatant, which we have seen yesterday. Uh, then um, then amendments were made. The Military Commission Act of 2009 amended some of the provisions of 2006 to improve protection for the defendants. This happened because lot many people and their relatives, they went to the U.S. Supreme Court and demanded justice. The U.S. court, the government has also made number of orders with the approval of Congress denying habeas corpus to detainees at Guantanamo Bay in the usual court of law, and three U.S. Supreme Court decisions in Rasool versus Bush, Hamdi versus Rumsfeld, and Hamdan versus Rumsfeld had ordered detainees to access the court within the United States. But after a judicial mandate, but after every judicial mandate, the U.S. Congress, they came up with another legislation, and that's the reason they could not do much in this particular case. However, the situation became totally changed in the case of Boumediene versus Bush in the year 2008, when the U.S. Supreme Court finally, in 5-4 decision, held ouster of habeas corpus rights of these detainees under the Military Commission Act 2006 as unconstitutional, and the alternative process contained in the Detainee Treatment Act for scrutiny of designation of detainees as enemy combatants did not provide an adequate substitute for the writ of habeas corpus. So I want you guys to understand here at this point or at this juncture only that uh, by virtue of the laws of the United States, it was not possible for the executives or the authorities, those who are interested to combat terrorism in the US, to deal with such people, those who are suspected of terrorist activities. And as a result, what the solution they found at finding a separate bay, which is called as a Guantanamo Bay, and they arrested the people and they carried these people there in that bay, so that the U.S. law would be applicable there in Cuba in Guantanamo Bay. Because and as a result, but what happened was, in so many cases, their relatives went to Supreme Court, U.S. Supreme Court, and they said that this is something very much violative of the international treaties to which U.S. is a party, and time and again, the court has given the decision against the US Congress, against the US President, or against the US Executive. And again, they come up with yet another legislation. But this issue was finally being settled in the year 2008 in Boumediene versus Bush, when the US Supreme Court comprehensively dealt with the issue, and they said that US Congress does not have any right to make any such disappearances or transportation of such people and torture any kind of in the Guantanamo Bay or any other military base which United States military may have access to. And as a result, these decisions proved that fundamental human rights exist so far as the US is concerned. So this was, my dear friends, was the story of the uh, as to how United States has dealt firmly with the issue of terrorism. They have not only amended their major general criminal laws, but also amended or also tightened their illegal immigration process, border security, their technology act, and whatnot. So these were the measures from which India could have learned. But unfortunately, India once again came up with its own typical, kind of legislations. Now we will see. Any questions so far, by the way, on this? Any questions? I can give, I can spare 1 or 2 minutes. Any questions? Are you guys listening? Are you guys there?
Yes, yes, sir.
Who said?
Sahil.
Sahil.
Yes, sir.
All right. If there are no questions, then I'll just go ahead. Now we will see. Yes, question. Anything? Anybody said anything? No. Okay. Utkarsh, are you saying something? Utkarsh.
No, sir.
Okay, I heard some sound from your microphone. I don't know how.
And actually, sir, there was some problem in Microsoft Teams app.
Yeah, even I'm finding it very difficult. Mhm. Zoom could have been even better, I guess. Then we can do a lot of things here. There's so many restrictions. But anyway, uh, now we will have a look at how in India anti-terrorism laws are there in existence, right? We will have a look right from the time of the Britishers, then we'll come back to the post-independence, and then we'll come back to the modern laws that we have, right? We have very less time, and I have very much to say. So reserve your questions in the last, I would say, and then at the final 5 minutes, we can then at the final 5 minutes, we can have the question and answer session if you or we will make a comparison between the US and the Indian lawmaking system, right? And then we can have a small 2 minute discussion or question and answer session if you have. Then these are the anti-terrorism laws that we have in India. Uh, Beginning with this small introduction, we have a Indian independent India's constitutional tradition is very much proud one, and we have a durable, enduring, and ever improving commitment by India to protect the fundamental human rights can serve as an example, international example, and we have proved it in the Ajmal Asaf case. Terrorism has affected India more than the most of the countries because we are the neighbors to the unhappy neighbors which are there, and we are surrounded by very hostile nations, for example, Pakistan, Afghanistan, and there are so many. So its laws, anti-terrorism, and other security laws have periodically been enacted, reenacted in the recent year, and so many times it is Indian judiciary which has reprimanded the legislatures, and they said that you have committed gross violations of human rights. We'll see very soon as to what were the laws right from the Britishers' time, and we'll then come to the post-independence area. So, as you can see, there was following the Indian Mutiny of 1857, Britishers came up with the Indian Council Act of 1861, which authorized the Governor General to legislate any outside the ordinary lawmaking process in the emergency situations to ensure peace and good government of India. However, these extraordinary lawmaking powers were widely been abused, and this being used not only in emergency situations but also in normal peacetime. Further, there were two subsequent framework statutes, that is the Government of India Act 1919 and 1935, which also granted the Governor General similar power as that were there at the time of Indian Council Act 1861. Then these are the two legislations which were there prevalent during the World War II time, two period. That was the Defense of India Act 1915 and Defense of India Act 1939. But the Britishers used these laws again, not only in emergency but also in the normal times. Then came the 1818 regulation in Bengal, which granted the Executive General authority to take place the individuals under personal restraint, which again became the example of preventive detention law. And then came the 1818 regulations, which ultimately, you see, ended throughout or extended throughout the India. Then 1919, we had the famous Rowlatt Act, which became the focal point of non-cooperation campaign, which was led by Mahatma Gandhi, and the act ultimately lapsed or ended in the year 1922. This act also conferred new authority to order preventive detention or other restriction on the freedom of movement for up to 2 years of any individuals who the government has reasonable grounds to believe that these people were involved in an anarchical or revolutionary movement, and where they're roaming around in the unaffected areas. So, however, this act ultimately been cancelled or repealed in the year 1922. And please, then we do had, I'm sorry, we do have this Government of India Act 1935 again, which granted provincial legislatures authority to enact preventive detention laws. Whenever India faced with the problem of terrorism, we again and again came up with the preventive detention laws. This remains the sad reality even after so many days of independence. Now we will have a look at the post-independence laws. What were the laws in the post-independence India? The very first law which we have is Preventive Detention Act. It is known by the name of PDA 1950. Within very few weeks of the Constitution went into force, it was enacted, which authorized the detention up to 12 months, both by central and the central government if necessary, to prevent an individual from acting in a manner prejudicial to the defense and security of India. By virtue of this PDA Act, not many individuals were being detained by the executive without any kind of reason, and as a result, there were a lot of huge cries from the public, and finally it elapsed in the year 1969. However, though the act is no more, all its successor anti-terrorism laws, they have derived main body from this PDA Act only, right? This was again challenged in the various kind of constitutions. Then there came the emergency period in India, which you and I are very well aware of if you have studied the constitution. In the year 75, there was an emergency. Then there was this 1971 Act, Maintenance of Internal Security Act, MISA. It is known, or it is known to be kept after the daughter of Lalu Prasad Yadav. Her name was also MISA. This act is also MISA. So it became instrumental in the emergency time during the period of great Indira Gandhi Madam time. Then Preventive Detention Authority returned in less than 2 years, which restored largely the provisions of PDA 1950. Then these laws were amended during the emergency to permit much longer period of detentions. Earlier, the period under PDA was 12 months, but now there could be much longer period of detention, which makes it easier for the government to exercise detention authority, courtesy Sanjay Gandhi of that time, right? And let me tell you, these are the official records. So ultimately, over 1,11,000 people were detained under visa and other laws during the emergency period. Finally, after the Indira government was no more in power and the Janta government came in the year 1978, the visa war has been repealed. Okay, then after visa emergency period, we have this act, which is even now in force, and which usually permits interest parliament to impose reasonable restrictions on freedom of speech and expression in the interest of sovereignty and integrity of India. Mainly, this act is being used to ban any organization which is working against the interest and sovereignty and integrity of India. And you see, once the organization, any terrorist organization or any organization for that matter is banned, then the government could use lots and lots of restriction even on the membership of such you see organization. So this act is even now is there in force, right? Then we have even this act even now in force. It's called National Security Act 1980. It remains in effect today, restored many provisions of the PGA and pre-emergency power version of MISA, and its stated purpose is to combat anti-social, anti-national elements, including secessionist, communal, pro-caste elements, etc., etc. It authorizes against the detention like the same of PDA Act 1950, that is up to 12 months, um, and both under the permissible ground for the preventive detention, right? Then we have after NSA. Now these were some of the controversial acts that we are going to have a look at, and then we are going to have, you see, then we are going to come to our existing legislations again. Yes, once again, very much controversial uh, act had came up, and you see, the interesting facts about these legislations are whenever there happened a terrorist attack or matters of public order, disorder, or something like that, the government came up with immediately the act. Now, 1985 was the period when our dear Prime Minister Indira Gandhi has been assassinated, right? Immediately, the moment it happened, the Parliament came up with the Terrorist and Disruptive Activities Act 1985, that is TADA, and introduced two new offences, namely Terrorist Act and what do you mean by disruptive activities? It also established a system of special courts, which were popularly known by the name of designated court, and place restriction on the grant of bail, which means if you are a judge of the designated court, you cannot grant bail unless there are reasonable grounds to believe that the accused is not guilty. Also, it enhanced powers of detention of suspect, and even provided for the speedy trial. Okay, then these were some of the interesting provisions which I think you must know. Um, After 2 years, it immediately again was amended, and the main features of TADA were amended from time to time and introduced certain new offenses like harboring or concealing terrorists for being a member of terrorist gangs or terrorist organizations. Then it also came up with a new invention called notified area, or provided a new offense of possession in any notified area of unauthorized arms or bombs. uh, Actor Sanjay Dutt is being the victim of this particular, amendment in the year 1978, which was made. Uh, it also provided enhanced penalty for certain specified offences, such as offences with arms and ammunition, and if committed with intent to aid any terrorist or disruptionist, which means when the Sanjay Dutt trial was going on, these were the provisions that haunted Sanjay Dutt's trial. Otherwise, we could have scot free without any difficulty. This act also gave enhanced power to the investigating police officer. Once again, what they have done here is they have made confession made before the police officer admissible, which is not there usually admissible under the Indian criminal law. If you have studied section 27 of the Indian Evidence Act, it states that if the confession has been made by a police officer or before a police officer, then confession will not be admissible in the court of law. That would not be admitted in the court of law before any court proceeding. So it also made a significant departure from the general law by rendering admissible confession to police officer. Right. This was also one of the important thing. The legislature also introduced a safeguard against the abuse of powers and extended benefits to the executive. Right. Then it as it was bound to happen, ये तो होना ही था. Again, the TADA was being challenged on the basis that it is violating human rights of people and violating the general criminal law, because as we have seen that even confession made before police officer is being made under TADA. So the constitutional validity of TADA was being challenged in the Supreme Court and was subject to judicial review. So in Kartar Singh versus State of Punjab, the Supreme Court found the law to be generally valid, passing the muster of constitution, and the court struck down as unconstitutional one of its important provisions, which had provided for identification of the accused on the basis of the photograph during the proceedings in absentia, right? So, which means under TADA, a witness could identify a particular accused even on the basis of the photograph, which could be shown to him by the police officer in the absence of the accused. So this was something which was very unusual of the TADA. And then in this particular case, there were some guidelines which were laid down by the Supreme Court again. It talked about free atmosphere and use of language, and this decision has made actually significant contribution to the jurisprudence governing counterterrorism measures in India. And it mainly came up from the point of view of formation of a review committee. Then, in compliance with the Supreme Court direction, a screening committee or a review committee was constituted by the government in various states. It was a high power committee under the chairmanship of the chief secretary of one of the particular unit of Union of India, who reviewed the prosecutions made under the TADA, and government conveyed its approval to the director of prosecution for deletion of charges which means this committee was made on the basis of the Supreme Court decision to recommend as to whether or not the trial should be go on or should be dismissed. So uh, several charges were also been dismissed by this particular committee. Then we have in the year 2001 we have Prevention of Terrorism Act 2001. Now, can anybody please tell me as to why we needed this particular law on POTA in the year 2001? Any idea? Any idea you guys have? Anybody? All right.
Sir,
The
it
thing,
basically was with the objective to strengthen the anti-terrorism operations in more systemized manner than before.
just remember what I said. Whenever we had something going on in the country, we are coming up with a new law. So what happened in the year 2001?
So there
Like
was a
in the
parliament
year
attack.
in the year you see in the year 1984, Indira Gandhi assassination happened. In the year then you see there was this communal riots of 1993 and there is bombings in Bombay, and there that's where the tada gets more uglier, and the police started behaving in much brutality. They were arresting any people anytime. So this tada has relapsed way before 2001, and we had no law. So in the year 2001, what happened?
So this
Sir,
act was
attack on the parliament
sir,
was there, I
Sir,
guess.
controversial.
Parliament attack.
Parliament attack.
Exactly. In the year 2001, 9/11 happened in US, but before that, Parliament has been under attack, right? So it was the government. I think that time the BJP government was in power. They came up, and if I'm not wrong, Advani, Lalkrish Advani ji was the Home Minister. If I'm not wrong, I stand to be corrected, guys. Then this, in the aftermath of terrorist attacks that were happening in the Parliament, and even the Lal Killa, if I'm not wrong, am I right? Lal Killa attack and these Parliament attack were one and the same, or they are different?
Different, sir.
Different, right? Right.
Sir, they both were
Then
different.
right, yeah. Then terrorists attacked the Indian Parliament, which was considered to be the hallmark of the world's largest successful democracy. Immediately, the government came up with the similar law like TADA, and which conferred special powers of arrest and detentions of suspected terrorists, of seizure or forfeiture of terrorist property, for prohibiting penalizing terrorist funding, because you see it was very much important for the police officials to go and search some of the premises which were suspected. And so this POTA Act gave sufficient grounds and sufficient reason for the same. And it contains the revised definition of terrorist act as was there in the you see in the TADA, and it provided with the intent to threaten the unity, integrity, security, and sovereignty of India, or to strike terror in its people, which means an individual must not actually do that. But even if you have an intent to threaten or to strike terror activities or to threaten unity, peace, security, and sovereignty of India, then also a person could be arrested. The law under POTA also permitted the use of confessions made before police officers, as was its predecessor act, TADA did. And as a result, again, ये तो होना ही था. This POTA also got, you see, challenged in the court. However, this act also provided measures to deal with organizations like UAPA, but UAPA we have already had this revision, but here some more stricter rules have been added. Then, beside introductory of safeguards, the abuse of POTA, um, abuse the power, restate to confession before the police. POTA also provided for speedy trials, introduced the concept of quasi-judicial review. Like in TADA system, we had the reviews committees. Here we have the quasi-judicial review of the state actions. which organizations declared to be terrorist organizations. So again, as I said, it bears a special mention that the central government put the mechanism by constituting a review committee, and the same committee was also there in the time of POTA. POTA also came up with a sunset clause for the expiry of for the after the end of 3 years, and it came to be repealed ahead of its time with effects from 21st September 2004. Then constitutionality of quota was also being challenged, but found without merit. However, in People's Union for Civil Liberties, for Union of India, the challenge was on the ground that the basic human rights are being violated, and the view of this regard is well known now. Even now, after so many years of this case, even the Indian judiciary follows the same, wherein the court stated that the protection and promotion of human rights under the rule of law is very much essential in the prevention of terrorism, which means the court has said that no matter we are allowing you to deal with or combat with the terrorism, however, at vis-a-vis, you should also understand the values of the human rights and the rule of law. And whenever you are dealing with the terrorism issues, protection of promotion of human rights is also very much necessary. Okay. Then we had attacks on in Mumbai once again in the year 2008, and we know it by the name of post. We know it by the name of 2611 on the line of 9 and 11 of America, right? Then after the attacks, there were two bills were passed. First one was UAPA Amendment Bill 2008, wherein some of the most groups were also being listed as a terrorist organization, and there was this NIA Act. It was a bill. It is not a bill anymore. It is very much full-fledged act. Even now, after you see, after 14, 13 years, even this act is now in force, and much has been done by virtue of this particular act. Then this act made a number of procedural substantive changes to the NIA effectively, that is Unlawful Activities Act. Then a new section added which incorporated and which has increased the maximum period of custodial interrogation to 180 days. And Section 43E introduced the conception principles of presumption of guilt. Now this is very much important amendment that has been made under UAPA. Why? Why? Because if you see the general criminal law of India, the presumption of guilt, that is the onus of proving, always lies on the prosecution side. I hope you have studied the evidence law. Am I right or wrong? You have studied evidence? You have studied CRPC or something like that?
Yes,
Anybody?
yes, sir.
Right. Yes. So we have an adversarial system of working here in India, wherein it is upon the prosecution to prove the guilt of the accused beyond all reasonable doubts, and this is the well cardinal principle of criminal law of India, so far as concerned. Then this Section 43 makes a significant departure from the same principle, because now it says that the principle of assumption will, or the onus of innocence will lies on the accused itself. It is his duty to prove innocent himself, and no more a duty of the prosecution. So this was one of the important, you see, amendment which was being made by UAPA. Then we have this National Agency Bill, not Bill Act again, which had established several important provisions. This law is applicable to whole of India. It created NIA, National Investigation Agency, and also constituted special court. These special courts are usually being headed by the judges of the High Court. Okay, and the Supreme Court, the superintendent of the NIA is vested usually in the central government. The state government shall extend their assistance to the NIA, and the Act also provides for procedures to be adopted and powers to be exercised by the special courts for the trial of specified offences. Now, if you see, sorry again, if you see now the functioning of the NIA court in India, even the counterfeiting crimes or offences which were there in the general criminal law of India, now these are being treated as an international, or these are being treated as offense under the NIA Act. This is something very much important and recent which is going on under this NIA Acts. And now we will see We will see some of the best practices that can be there exercised. Then India has followed a path wherein rule of law continues to be a fundamental benchmark, and India responds throughout aided by the principle of universal respect for and observance of human rights and fundamental freedoms. Then recent trial of Amir Ajmal Kasab demonstrates very clearly the India's adherence to the principle of natural justice and respect for the law. And this was the speediest trial in the history of anybody. Then there are periodic laws, review of the laws of the NIA that are happening. Then concept of judicial review is also there available in India time and again by virtue of the. I think I have finished the slides. Yes. So we have even the concept of judicial review, which has successfully been implemented by our pride of India, that is Indian judiciary, which acts as a major check on the abuse of power of the executive as and when required. And it also acts as a safeguard for minimizing the illegal detentions of the people. Okay. Now your international terrorism topic is over. We have dealt with international law of the terrorism. We have dealt with the United States and its response to terrorism. We have dealt with the terrorism and human rights because we have told you that no matter anti-terrorism laws are there, but there are some human rights available to the accused people or even to terrorists. Then we have also seen, then we have come with the Indian scenario. I've told you how the preventive detention laws were there in right from the Britishers, how they have been misused, right from the Rowlatt Act, the Indian Government of India Act, Defense of India Act 1935 and 1919, and then we have dealt with the PDA, the MISA, then the NSA, UAPA, then you see we have also seen the TADA and the POTA, how the laws in India have been misused by the police officials, and how many thousands and thousands of people were being arrested. You see, without any kind of discrimination, and this happened mostly in Gujarat that time. The POTA was misused in Gujarat in the aftermath of Godhra Hatyakannd, and the TADA was being misused brutally by the police officials or the executive in the aftermath of 1993 bomb blast and the communal riots. So when it comes to the implementation part, the executives, or mainly I should say, the ground level enforcement, they have brought a big shame on the Indians when it comes to, because these POTA and TADA both were criticized at international level, and there was a lot of name shame of India when it came to the handling of these events. So unfortunately, POTA has been misused in the aftermath of Godhra Kand, and you see now we have NIA, which has successfully been going on, and we have proper safeguards established because we have learned from the TADA as well as POTA as to what happens when you do not draft properly a law which is called as anti-terrorism law, and how you can you see violate mercilessly with brutality the rights of the common people, which have nothing to do with the term terrorism. So many innocent people were being falsely fabricated or falsely being accused of the crimes mentioned in TADA as well as in POTA, and we had you will find lots and lots of reports of these people, innocent people, and some of the cases are even going now, right? Because TADA, remember, it came up with the even you see even when the act got over, it was applicable, like it happened in the Sanjay Dutt case. Okay, so I think all the units which were being allotted to me are now over, and if I'm not wrong, then I have finished all the units successfully. From tomorrow or the day after, your another madam, I think she's going to resume your classes of public international law. And just to tell you, as I promised, so far as your assignments are concerned, please do not worry about the same. That they will remain under the same condition like I promised, because I will personally see to it that justice will be done to those who are regularly attending my classes, because I can see your name on the regular basis, right? So you guys do not please worry about the assignment part. That I'll 100% take care. You please focus on studying the major topics that are there. Okay. Any questions so far? So I think I have finished my portion. However, if you require, or if anybody else require me to deal with some other topic under international law, then I'll be free to do so. However, I think yeah, that's all about. That's it all about. If you have any questions, please feel free to ask. It was lovely to interact with you guys. It was lovely every time, every evening to see you guys, uh, and it's beautiful, right? Any questions so far? No questions? Am I audible, guys?
Yes, sir.
Yes, sir.
And yes, my presentations and or whatever my presentations are there will be visible to you very soon. I'll make a link wherein you can even go and watch some of the videos that are there, because I made sure that these videos are being recorded and should be made available to you as and when you require it to study it to them to understand. Apart from this, if you have any questions anytime pertaining to the public international law, you can please feel free to ask me anytime. I think, and I'm sure that my number is there in public. You can easily find it out if it's not there, and you can reach it out to me. I'm always available in the office hours. Okay. Any questions so far? No. No questions. When are your final exams? Any idea, guys?
Sir, something around 15 July.
15 July. Oh, that's good. And then you have the full June to study, right?
Yes, sir.
Okay. Then I guess I must. Can we have a last session on Saturday? One more session on Saturday evening.
So we
Yes,
can
sir.
have on Monday, because on Monday we are having ADR exam as well. So if it's okay with you, we can have one session on Monday.
Uh, why I want you see one session, because I think we have still not discussed the diplomatic communities and provisions. Diplomatic immunities and you see consular relations. If I get just one opportunity to discuss the same, and on Monday maybe, then it will be just simply great. But provided if you guys allow.
Yes, yes, sir. It would be
Yes,
okay
sir.
for us on Monday.
No, I want to know, Sahil, I want to know the opinion of all those who are attending the classes.
Yes, sir.
Starting from Akash, Akash
Yes,
Kumar,
sir.
Anisha,
Yes, sir. It's okay.
okay, Anita,
Yes, sir.
right, Anjali. Anjali is not there.
Yes, sir.
Anjali, you're there.
Yes, sir.
Okay, what do you say? Anjuman, Anjuman is not there. Anjuman is not there, I think, almost all the time. Chetan Papa. It's Chetan Patwa or Patwa? Apratim.
Patwa.
Patwa. Okay. Chetan,
Hello,
where are you from, Chetan?
sir. Apratim this side. Did you call out my name?
Ah, yes.
Uh, yeah,
Just to make
sir.
sure whether you're there or not.
Sir, I'm there. And I don't have any issues if you conduct a lecture on Monday.
Thank you. Chetan, where are you from,
Thank
Chetan?
you, sir.
Chetan, where are you from, Chetan? Chetan is gaib again. Then Dhairya, are you there? I don't know many of you. Can we have a meeting? Can we have a lecture on Monday with all your videos on, please? So that I can at least see you and know you by name. By name only I know you now.
Yes, sir.
Okay? Because I really want to see you, all of you. Some of you I know you already, I guess. Uh, but some I want to see you so that at least let me know whom all the days I was teaching so that we can have at least a brief connect of the same. Right?
Sir,
Who is speaking?
sir Mansi.
Yes, Mansi.
Sir, outer space topic you won't be teaching us.
Out. Just give me outer space. I think no, that madam will teach you because
Yes, sir.
just
Sir,
give
I
me
think.
1 second. I'll just find out.
Okay, sir.
I'll just find out because outer space I was not with the same. Uh, outer space unit. Yeah. What is unit number?
Sir, 8.
8. Right. Yeah, 8 is in not my list. Even you see, even uh, even states, that is topic number 4, was not in my jurisdiction, but still I have dealt with the same because without taking the state in general, I could not make you understand. Okay, so even unit number 4 I did not have in my
Sir, actually,
list.
unit 5, 4, 5, and 6 all are interconnected in sort of ways. So, because unit 4 talks about state in general, the definitions and all, and unit 5 talks about recognition of states and then the succession.
Yes, yes. Now you guys already know about the states in general, at least
Yes.
some of its part, and classification also of the state we have dealt with. And now only these are recognition and state succession. These are actually the theoretical part, and that's why I didn't wanted to indulge myself into that. To be very fair, right? So rather I dealt with the treaties, settlement of disputes, ICJ, and international terrorism, and even you see, even law of the sea, right? So I think this other madam will take care of the same. Okay,
Okay, sir.
and even if even you see this when it comes to states in general, topic number 4, even diplomatic privileges and immunities I was not supposed to take, but I'm interested more because this is again one of the practical subjects wherein you'll find so many cases, and recently India's Jadhav case, and that's why I wanted to have one lecture on this, right? So we will have something on this Monday pertaining to domestic, not domestic, diplomatic immunities and privileges, and also we'll see how consular relationships, how consular convention 1961 is helpful even to the people who are not, you see, official diplomats and all, right? Because even individuals are being protected by virtue of exercising this jurisdiction, and how in the US several people brutally been executed in spite of the guidelines given by the ICJ. How some of the Italians were being killed by the US court. This also we'll see on Monday. Okay, because this is one of
Okay,
the
sir.
interesting and important topic which I would like to take. Right.
So, we
Mm,
can also do it tomorrow if there is no issue.
tomorrow would
And
be quite difficult for me because I'm busy in some other tasks only. Uh, so I think today is what, Wednesday, right?
yes, sir.
So we will deal with the same on Monday. Okay, with the permission of all. If not Monday, then
Yes, sir.
maybe if not Monday, then maybe Tuesday.
So Monday would be
Okay.
fine.
All right, then Monday. But I want to see you guys, so we'll have an you see open camera system of having a lecture at least for 5 minutes at the beginning, and then I'll tell you about mm, the topic that has been remaining. Okay, and I'll also tell Jaishi madam to coordinate with the other madam so far as your status of lectures from tomorrow, because I think only few topics are remaining of so far as public international law is concerned. But as I said again, if you have any doubts, any confusion, any kind, if you want to talk to me, then I'm available for you. Okay, I will be
Okay, sir.
happy to answer your queries. Okay, and when it comes to the final examination, which Sahil is saying that it will commence from July, but right, Sahil.
Yes, sir.
Then after that is in June somewhere, depending on your convenience and your interest, we will have one session on which will wherein I would like to prepare you for the final exam attempts, right? So I will tell you where to focus, how to focus for from the examination point of view. Okay, is this fair enough? We can decide any day in the month of June mutually, and we can you see just half an hour session or just 15-20 minutes talk interaction. I want because I want to tell you about how to appear for the examination and what could be the areas that you should be focusing on. Okay, it is fair enough.
Yes,
Please
sir.
answer,
That
guys.
grateful.
Yes, sir.
Okay. Okay, then thank you so very much for being a part of my public international law class. I will see you as planned on Monday. However, please be remindful that if for some reason I could not take the class on Monday, I will inform you the date as to when next I can take the class. Okay, and then I would request you to please be attentive on the same day. Right? I think this much is enough, and thank you so much. I'll see you by Monday. So far as your tomorrow's lecture of PIL is concerned, I will talk to Jashi madam. I'll let you. She will let you know about the status. Uh, so have a very great Wednesday night, and I wish you all the best. Just rock and do whatever you want to do. Thank you so very much. And can somebody please play music apart from not Sahil, not Sahil? Can somebody volunteer please? Because बेचारा साहिल ही सबसे ज़्यादा interruptive यहाँ है, I guess. Apart from one or two, so I don't want to bother Sahil. Anybody would like to volunteer for a song for just 1 or 2 minutes?
Sir, yes, sir. Would you like to listen to Bhojpuri music, sir?
Bhojpuri. That would be lovely, I guess, and I'm sure that nobody would have objection on the same. Yeah, please go on.
Really, sir? Okay.
Yeah,
Krishna
why
play
not?
good Bhojpuri song.
Yeah, let's play.
What?
Let's cheer up everybody. I hope everybody is okay with the same, and nobody is
Yes, sir.
minding the same. Or even if you mind, just leave the class. Thank you so much. I'll see you later.
So his taste is very nice. So you will be happy after listening.
Okay, okay, yeah, please.
Just a great minute.
Krishna, are you there?
Oh,
There
Is it audible, sir?
hello, sir. Hello.
you are audible. cannot hear the music.
You have to sing, bro. Sing a song.
Oh, you really want me to sing a song? You
Yes, we'll have
cannot
to.
tolerate. You cannot tolerate me.
No,
Sir,
no,
actually, I
then
have some network issues, sir, so I am not able to play the song. Sorry, sir.
okay. Who can play?
But at least you can sing for us.
Said, let's not take that risk. He has said that he is horrible. No offense, no
So you
offense.
play favorite song today.
Who is saying this?
Kavishwa से BLLB से because मतलब even I have
Can you?
network issue that I was not phone.
Who is
Yes,
speaking?
sir.
I'm
Sir,
not
you
getting
can play a music of your choice, a local, any local music, sir.
any local. Local, matlab?
Marathi. Local, I mean, sir,
Music
like
from
Marathi
mountains.
and Punjabi, Bhojpuri, like that.
Sir, like regional music.
Yes,
Yes, regional. Yes.
yes,
I would play. Uh, I'll just give me somebody. You all please mute yourself. I'm just playing a Lavani song. Okay, this will remind you of Pune.